Good afternoon, ladies and gentlemen. Thank you for coming to this press conference. My name is Kevin Carnes. I run the U.S. Business and Industry Council. We are 2,000 manufacturing businesses, domestic manufacturers that are opposed to H.R. 1249, and we and other organizations have been helping these members of Congress and others to oppose the bill, to gather signatures on the so-called rules letter, requesting the constitutional debate on this, which is a new rule in the House. Speaking for USBIC, we believe the bill is unconstitutional in several respects. It contains a bank bailout in Section 18. It disadvantages small entity inventors. It protects large market incumbents who don't want disruptive technology coming into the market and stealing their market share. It tries to harmonize with less successful patent systems, such as Europe and Japan. And there's no need for this bill. What we need to do is straighten out the mess at the Patent Office. Congressman Sensenbrenner can address that better than I. But if we straighten out the mess at the Patent Office and do a funding-only bill, that will be sufficient for the time being. Then we can see, after we get the Patent Office out of its dysfunctional state, we can see what else we might need to do in the future. So I'm just going to serve as the Master of Ceremonies and make the introductions. I'll start off, ladies first, with Marcy Kaptur, Congresswoman from Ohio. Do you want to go first, Dana?
Whichever. Okay.
All right. So the lady has deferred to me.
His party's in charge of the house, I think that's...
Here is working bipartisanship. Right? Ladies first.
All right. This has been a fight that has been going on for 20 years with very little notice of the American people or even by other members of Congress. But Marcy Kaptur and I have been in this fight all this time. We used to be young kids when it started. And the fact is that there has been a dramatic effort made on the part of a group of very powerful groups in our country and throughout the world to change the fundamental patent law that protects the American people and their creativeness and their innovation. We have had basically a commitment by very powerful multinational corporations to globalize patent law. And just like any other individual right, America's rights that are protected by law have a higher standard of protection than other countries. I mean, we have our constitutional protections are higher and much stronger than those protections for individual rights in other countries, and that's especially true of patent rights. And so if they call for harmonization, of patent law and patent rights throughout the world is actually a maneuver to reduce the patent protection of American citizens. And it may sound good, overall we can have one big global law that we can, we all know it is all applicable to everybody. Yeah, well, if they were talking about freedom of religion or freedom of speech, all of a sudden everybody would realize what a threat it was to bring our level of protection down to what the world has. Well, people don't seem to understand that part about patents. It's the same way. And if they get away with this in H.R. 1228, 1229, that what we can, you're right, it's 1249, I've got it written right here. If H.R. 1249 passes into law and is signed into law, we will have weaker protection for our inventors, and we can expect that America's innovation will be stolen not only by other Americans, but by forces overseas. And perhaps the worst aspect of this bill, and the most blatant aspect of how this will hurt the American people, is in the very beginning basically harmonizing law in terms of the fundamental way we go about issuing patents. And in our Constitution, we leave this to Mr. Sensenbrenner and Conyers, the Constitution, it's very clear that someone who invents a patent is the one who should receive, or invents an invention, should actually receive the patent. Mr. Conyers. So, the bottom line is this. Our Constitution, the words are very clear that an inventor is the one who should receive the patent. The global standard is whoever files first gets the patent, and the fact is that will be very damaging to the people of the United States and changing the way we've done business. 50 of our fellow colleagues have joined Marcy Kaptur and myself in calling on the Republican leadership, who has made this their policy, that if 50 members of the House call for a constitutional debate on an issue, that any issue, a bill coming before the House, has to have a debate on the constitutionality. 50 of our colleagues have joined Marcy and myself in calling for that constitutional debate. And I am so proud that we have two former chairmen of the Judiciary Committee, Mr. Sensenbrenner and Mr. Conyers, who are willing to champion this cause. And what we are announcing today is a bipartisan coalition. Mr. Conyers, Mr. Sensenbrenner, Ms. Kaptur, and myself, and all the others of these 50 people on this list are demanding of the leadership of the House a debate on the constitutionality of the patent bill that is being presented before us today. We believe the patent bill to be unconstitutional and have dramatic negative impact on our inventors and thus on the standard of living of the American people. Marcy, would you like to say something?
Thank you, Dana. It's such a pleasure to be with you and with all of our dear colleagues today. And thank you all for coming. I want to join my colleagues in this bipartisan effort to oppose H.R. 1249, the so-called America Invents Act. Let me begin by questioning the very name of the bill. America doesn't invent. Individual inventors invent. And their rights to their own ideas are protected as an exclusive property right in the very first article of our Constitution, Article 1, Section 8. This bill seriously weakens these constitutionally protected rights for individual inventors in an attempt to circumvent their sole property rights to their inventions, be they writings or discoveries. The Constitution absolutely secures their property rights. This is because our founders knew their inventions assure the progress of science and useful arts in our nation, and in turn our progress as a society. New jobs and new opportunity have been created through their ingenuity in each century of our nation's existence. This patent right is very precious. It relates directly to economic progress in our nation and our ability to create jobs here at home. So at precisely the moment when America needs to create more and better jobs through innovation, why would Congress want to weaken the incentives for inventors and those who invest in their innovations? This bill will destroy more jobs in our nation. It will severely dampen innovation in our country. It will rob countless inventors of their rights. What is going on here is a fight between the individual inventor and powerful global technology corporations and their trade associations that want to weaken U.S. patent protections. For the very inventors on whom America's economic future depends. 15 giant technology corporations who have very deep pockets have mounted a multi-million-dollar campaign to change our Constitution to pursue their own agenda. Please let me be the member to name them. IBM, Apple, Cisco, Dell, Hewlett-Packard, Intel, Micron, Oracle, Palm, RIM, Symantec, SAP, Google, Autodesk, and Microsoft. These 15 companies were defendants in 730 infringement cases from 1996 to 2006. They were also defendants in 641 antitrust cases during the same period. They paid out almost $4 billion in infringement settlements, which is half or more of what was paid out for all such U.S. cases in that period. These corporations want to weaken the ability of individual inventors, small companies, universities, and private research institutes to protect their own inventions because they might challenge them in the marketplace. For small inventors, patents and the threat of court-ordered damage awards are their only protection from the giant, deep-pocket corporate infringers. Without a strong patent system protecting the small inventor, inventors effectively lose their constitutional right. What this bill does is move the constitutional protections from the inventor who is the first to invent to a system of whoever is the first to file at the patent office. Quick-footed giants with lots of lobbyists can make track to the patent office faster than an inventor sitting out in a garage in Ohio. The lawyers among us, and they are here with us today, in the Congress on a bipartisan basis agree this bill is an unconstitutional reach by those who wish to harm our patent system. I'm really honored to stand in the presence of former chairs of the Judiciary Committee, Congressman James Sensenbrenner and John Conyers, who agree that this patent bill is unconstitutional. Dana has covered the fact that we have gotten the necessary 50 signatures to have this debate on the floor, and this is because this Constitution belongs to all of us. An inventor's invention belongs to him or her alone, as the Constitution assures. With us today are several legal scholars who will address in more detail the unconstitutional aspects of this bill, including the first to invent versus first to file and prior user rights provisions. Our patent system is the finest in the world. There are patent concerns Congress should address, such as the high cost of fees for inventors who hold less than 3 patents. However, this legislation is dangerous, unconstitutional, and should be defeated. Thank you so much for all being here.